Very well. Let's have some questions. If you just raise your hand if you want to ask a question, tell us who you are, where you're from. We get a microphone to you. Gentleman here, please.
James Thompson from Cullen International. Regarding this Skype case and the request from Belgium, from a prosecutor in Belgium, is my understanding correct that currently all wiretapping requests to Skype would have to be channeled through the police in Luxembourg? Is that how it should work at the moment, that the prosecutor or the police in Belgium would have to channel the request to the police or the law enforcement authorities in Luxembourg to get the wiretap? Is that how it works? Or?
That's indeed the interpretation that is given to it by Skype, indeed, because they say we're localized in a different country. And so since we are not in your territory, it's like if you compare it to human beings and you say, I would like to interrogate a person, but that person is in Luxembourg, then you have to call your colleagues, or you have to request your colleagues in Luxembourg and ask them, can we interrogate this person? Can we interview that person? And then you have to go through the AMLET agreement. So that's basically, that's the old way of doing things, and that's what AMLET agreements are being made for. It doesn't work today. I agree with you.
What is the link with Luxembourg? Is it just because Skype is headquartered in Luxembourg, but where is the server, or where is the data?
Well, of course, the infrastructure exists in Luxembourg, the communication infrastructure. But of course, one of the second level of challenge, once you get beyond the kind of conflicts of law kind of issues, is because it is a peer-to-peer call, it's not running through any server of ours that we could like put the alligator clips on, to use the very simple form of, so there's no place to do it. Now, governments could decide they want to legislate obligations that services have to have intercept capability. There's certainly precedent for that in the transition in telephony from analog to digital. But there was a statute that was clear about doing that. And I think today, the question is, how many of our services that we operate, should have an affirmative obligation to have an intercept capability? And I think it's really an interesting thing to discuss. It's a very hard question to resolve, though.
I like the name Alligator Clips for an intercept app. Another question? Just raise your hand. Well, I was super quiet. Jennifer.
Hi, Jennifer Baker. I have two questions. The first is sort of a comment, which is that we've assumed you mentioned third countries, and we've mentioned the US. And as much as I love the EU, though, I think we need to admit there are countries within the EU where rule of law is currently very questionable. And do we really want to give access to those authorities our data that they currently don't have in an easy way and ride roughshod over MLATs? But the main question I want to ask the panel is, what does meaningful redress look like if I, as a citizen, have had my data accessed in an unlawful way or in a not perfectly accurate way, if, as Catherine says, most of us don't really care or know where our data is? And I mean meaningful redress, not as we currently see under Privacy Shield or previous Safe Harbour, which is theoretical redress.
Vanessa?
Well, I think that's a very valid question, and very often you see notions like judicial review or redress, or sometimes you see the requirement of a notification to the other state popping up, and it's not clear what we're referring to. It's really not clear. So I think with the new EU legal framework, these safeguards should be as specific as possible, I think. They should be as specific as possible, EU-wide, but that will be a tremendous challenge because if we look at the difficult process that the Commission and the other stakeholders have gone through, for instance, for the EPO, the European Public Prosecutor's Office, and at first we had more or less EU-wide safeguards and the member states didn't want it. So this is really a tricky issue, but I fully agree with you that this is a crucial point.
Jennifer, do you feel that people have a clear idea in their own countries what redress would look like, never mind getting into the European dimension?
I think in your own country you find it, you go to your local courts or your local data protection authority, and I presume at least everyone feels they can do that. the question becomes difficult if we're talking about cloud preservers, and you've only to look at the Max Schrems case to see that it becomes so ridiculously complicated that the average citizen can't really do it.
John?
I think a prerequisite to any remedy is knowing that it took place.
Yeah.
And so I think that it is really important to have a notice provision. We've sued the United States government, I think, 4 times on this set of issues, and just a couple weeks ago, the Department of Justice agreed to change its rules about, no longer just sort of as a matter of course getting gag orders that prevent us from notifying customers. Now, there's going to be some times when you need a gag order for particular purposes, but it should be short and it should end, and there should be able notice given. So I think focusing on the notice provisions becomes a very important part as a foundation for any accountability and redress.
Catherine, you have a comment on this?
Well, I mean, just to say that independently of what we do, we have already very detailed provisions in both the General Data Protection Regulation and the Data Protection Directive for the police, which institute an obligation in principle for both the companies and law enforcement to notify the target when there is any data processing going on.
Marco, you sense in the Council, is there sufficient trust between member states when it comes to these kind of agreements? Is this part of the problem that we're not confident that there would be redress given in an appropriate way within certain member states?
I think there is trust, and also in the Council of Europe, for example, which has a bigger membership when it comes to the Budapest Convention, then currently we have 56 state parties to the convention. But again, that means that, of course, the solution, the framework would be more global, have bigger coverage, but also at the same time, reaching a compromise would be more difficult than usually. But of course, conditions and safeguards, including rules on notification, rules on redress, must be there. And also when it comes to criminal proceedings, then principles of lawfulness, necessity, proportionality, these need to be respected all the time.
Catherine, is an element of consumer protection involved here as well? Is this something which the Commission considers? And instead of just looking at the fundamental rights, the e-privacy rights, is there competition law play in this as well? Is there consumer law at play in terms of protecting Europe's citizens?
Well, I guess you could see a competition aspect in the question of whether we can apply the same law to all the players on the same market. So if we look at how competition and consumer protection law works in the EU, it basically uses different connecting factors. It says if you come here, you have to play by our rules, and we apply those rules. So in a sense, they've already taken a step farther than we have, but that's for a good reason, because here we're in a criminal procedural law framework, so we have to step very carefully because the impact on the individual is of a different size. But I think that indeed, I mean, consumer protection comes in from both sides. On the one hand, having more effective investigative mechanisms can actually help us better protect consumers after data breaches or other things, to basically give more effect to our rule of law, and hence create possibly, that's a bit of a pipe dream, a safer online space. I mean, that's really what law enforcement is also trying to do. And on the other hand, of course, it has an impact on the consumer as a data subject if data is now being requested in a more or less uncoordinated manner by different jurisdictions based on different sets of rules. So I think there is a possibility to possibly address some part of these divergences.
So do you think, as Jennifer said, the sense of redress, and as John mentioned about the gut feeling, if we feel that we're safe, that we're protected as consumers, then the economic argument for investing more and more quickly in cloud services could actually follow through with that?
Well, I think that is a far step, but of course maybe the discussions around this can also help clarify a bit what the different aspects of the debate are. I mean, you mentioned at the beginning PNR. I think we need to do more to clarify, when are we talking about individual criminal investigations, when are we talking about mass surveillance, what are the different competences and then consumers can make a more informed decision than they can now when they're faced with a multitude of different legal frameworks that potentially apply to their data depending on where it's stored, where they are, where the provider sits, any other kind of connecting factors that are currently, I think, just too complex it took us a long time to get to grips with it, and too complex for the average consumer to understand for sure.
Okay, Vanessa, an issue of criminal law and terrorism, counter-terrorism measures as well. Do you see a blurring of the lines in this as well, given that, for example, one organization that is involved in terrorism is also laundering money through criminal organizations, drug dealing, weapons, artifacts from Syria, for example, as well. So there's really no, when you get to this level of organized crime, whether it be terrorism or mafia, there's a lot of overlap. So do you have confidence that the separation of these distinct elements of law can be kept?
I think in some member states there is already not much of a distinction between what is surveillance and what is really criminal investigations. And the rules are not always so clear, but I think there should be a clear difference. And one of the ways in which we can make a difference is, for instance, to say, okay, you can collect data, but you can't use them, therefore, as evidence in court.
So the admissibility element.
The admissibility. I think in some member states that is very clear. In other member states, it's a very gray zone. And I think that may be really something to focus on.
Which member states are clear about this? You can name one.
From my perspective, I think the UK is quite explicit about this. And even though under the new legislation they basically say that they can do everything, but at least when it comes to admissibility, it's my impression, but I don't know UK law into details, it's my impression that at least there's a line that you don't cross. Whereas when I look, for instance, at my own system, the Belgian system, I mean, people are writing theses about this, and at the end, when they come to their defense, they still don't know to what extent you can exchange surveillance data to criminal investigators, and that's really problematic, I would say.
John, have you comment on that?
I think there's a bunch of very interesting issues in this, and I guess broadly speaking, I don't think a country, countries want to be able to feel they can solve problems by themselves, but around the internet issues, I think we're all in it together. And trying to solve problems unilaterally, I don't think will be very successful. And ultimately, the internet does have, we call it multi-stakeholder model. We, sometimes it's a very seemingly inefficient process, but that is the world we live in. And trying to figure out, okay, we need a system that works on the foundation of international law. You can't build rule of law on a foundation that doesn't comport with international law. And the way to do that is through dialogue between countries and receiving, and the EU is a great place to work on these issues because countries have agreed to share sovereignty and work through these issues.
You mentioned your blog about this. It was Westphalia 16...
The Treaty of Westphalia, 1648.
Yeah, and so explain this is the principle where we're starting from.
Well, but it's sort of the basic of international law is boundaries matter. What happens in my boundaries, I control. And it wasn't just what happened in my city and there's the land in between us and we'll fight about it. It's like, no, let's draw a line. And if it's in my jurisdiction, I control it.
So sovereignty.
Well, exactly.
And the move in European...
Right, and sovereignty. And so, our customer's email account that's been processed and stored in Dublin, Ireland law clearly applies to it. And the United States ought to recognize that it's a police action to take a copy of that email and have it delivered to the United States for their criminal enforcement proceedings.
Given that there was a censure yesterday in the European Parliament relating to one member state because of its rule of law application, do you have a lot of confidence that the rule of law and the protection of sovereignty will be diluted in this way?
Okay, if Europe and the United States, we're the beacons of the rule of law and our traditions and values on this, it's incumbent upon us to do the very best we can, because if we don't, nobody else will.
Another question? Yes, please. Microphone here, gentleman here. Just tell us who you are, where you're from, please.
Thanks. Ralf Bendrath, I work in the European Parliament for Jan-Philipp Albrecht. We actually filed an amicus brief in your case in the appeals court and are working now on another one for the Supreme Court. So I think with respect to third countries, it's clear to me that this must be based on some kind of international agreements, MLATs and so on. It's more vague maybe or open what we do within the EU. And I always wonder when I go to events like this here, people talk about MLATs and a lot of case law and what have you, and nobody ever mentions the European investigation order. So maybe to Katrin and Marco, is this part of your considerations? Will it just be amending the investigation order or a completely new thing? What are you working on?
Catherine and Marco.
Right. I think the European Investigation Order is very much a part of what we work on. And in fact, a lot of the practical measures target the European Investigation Order as it applies to electronic evidence and try to make it more efficient so it will actually respond to the need. It remains a mutual recognition channel, so there's there's long delays if you compare it to the time for which data is kept in member states. And I think it's important to remember that often we're talking about an iterative process. So law enforcement will start looking into a case. The first step might be, okay, they have some sort of a lead, they have an account name. They will go to the provider and try to find out who is behind that account. And then they might want to go back and see, okay, when did they access that account, because they've, in the meantime, discovered other circumstances around this account. And then based on when they accessed it, they might need to go to the internet service provider at local level and ask, okay, so who was using this IP address at the given point in time when this criminal activity occurred? So those are just 3 steps. If each of those takes 30 days, which is short, then usually there won't be any data left by the time you get to the second step, let alone the third. And that's why we're starting to see a need, or we have seen a need, and pretty much all stakeholders, which is remarkable, have agreed on this in the process that we've run, to make things more efficient. And a big part will be to make the European Investigation Order more efficient. So we're not trying to basically just put that aside and say we're going to start anew, this will replace everything. We're looking to provide a targeted solution that will solve those cases where you actually need to go swiftly. And just on this Westphalian issue, I think things were pretty comfortable in 1648. I mean, you basically had a wall around your city. You saw everybody who came in, and you knew who was under the jurisdiction of your city at that given point in time. In the evening, you closed the gates, and then you were set for the night. Nobody was going in and out, and it just doesn't work that way with data. There's absolutely no control that any sovereign exercises about whether data enters into your jurisdiction or leaves it, for that matter. We have rules that attach to that, and that's for a good reason. But there's, limits to how we can apply these principles nowadays. So sometimes, 1648 probably wasn't such a good place for women, so I'm not wishing to be back there. But just from the perspective of clearing which jurisdiction I'm under, which jurisdiction my data is under, which jurisdiction my various service providers are under, it was a very different situation.
Westphalia 2.0, Marco.
Right.
What's your answer?
I could just also add that, yes, European Investigation Order would make life easier, but it won't solve all the problems, because there will be still problems regarding time frame, communication, requesting data, disclosing data. And also one of the problems is that not all the European Union member states are implementing European Investigation Order. Also the situation that law enforcement authorities face quite often is that, yes, they see the data, but they cannot determine the exact location of the data. We are dealing with so-called loss of location case. And that means that even you could copy, you could download the data, which is apparently somewhere abroad, but you do not know whom to contact, which member state, which country, because it could be in your country, the data could be in other member state, but also it could be stored in a third country or even in multiple countries.
Can Europol correct that? Is Europol in position to be able to action that? Given that they already work with the judicial authorities, they know the points of contact. Is this not a...
still, it's a problem, and therefore also many countries. What many countries do is that they just go for the data. They just go and copy it, even when they know that it could be outside the country, outside their jurisdiction. Also, when it comes to principles of territoriality, then also a couple of examples from real life that explain why this very often is not working. In Estonia, we do not have big multinational data centers, but in neighboring countries like Finland and then Sweden, they do have. But yes, they could have physical control over the buildings, over the premises, over the servers, but they cannot access the data. And when they need data from this data center, then they still need to contact the authorities, whether in Ireland or in the United States.
John, shaking your head.
I disagree with that.
Okay.
I think that, you know, if you've got a data center in your country, you've got to have somebody you got a relationship with, and you can ask them, is this data here? If it is, you know, your local court order, I think, is compelling.
It's a custody and control element to this.
Right,
as well.
unless one wants to argue that the U.S. statute that we're challenging extends to protecting data that's stored by a service provider that does business in the United States, no matter anywhere in their corporate family, any data stored is immune from any other government's, review, which seems to me patently absurd.
Okay, can you bring the microphone back to this gentleman, please? Thank you. Your team's Supreme Court amicus brief. What way are you pitching it?
Wait until it's published.
Generally, any idea? What's the most concern to you?
What I just said, you can already read, most of the arguments are the same as in the appeals court amicus brief. We have an AMLET with the US, both on the EU level and the Ireland level, so they could have used that, and the case would probably been settled by now. And we have rules in the General Data Protection Regulation, for example, that explicitly prohibit European data controllers from transferring data to foreign authorities without a legal basis. So we just try to make the EU legal perspective clear in the amicus brief. And in the appeals court, apparently it worked.
Yeah, thank you.
Helpful.
One last question. Yeah, sorry, I can see. Thank you. Tell us who you are, where you're from, please.
Hi, my name is Alexander Whalen. I work at BSA, the Software Alliance, an association representing software industry, per the name. I had a question. I guess it's more geared towards the Commission, but I'll try to phrase it for the entire panel. So we're talking about a future framework that's debating either between an investigative measure built around production requests, which would allow service providers either to respond or not respond, or production orders, which is likely the outcome. So I'm wondering, since a production order would likely be a real deviation from current criminal investigative procedures, if it's of the opinion of the panelists that there should perhaps be some type of threshold for when you would use this to sort of ease any fears that member states might have for jurisdictional purposes.
What would you mean by threshold?
Well, some sort of list of applicable offenses that you could then use or utilize this production order for, so that it's not being used for all different type of offenses. I mean, I believe there's something exists like that in the European investigative order. Is that something that the panelists think that should be built upon, or is the idea instead that we should be able to use a production order for all type of offenses, or we think maybe some sort of threshold there?
Thank you. Catherine?
Yeah.
Right, just to clarify, the European investigative order applies to everything. So there is a list of offenses in there, but that's not to limit the use of the European investigation order. That's actually for another purpose, which is irrelevant to this discussion. But of course, I agree that, and Marco has already spoken to this very eloquently, that we do need conditions and safeguards to apply, and you can apply those in various ways. Saying, for example, that it should only work for serious crimes, that's one thing. Although there, of course, you would exclude a number of crimes where it's very relevant, such as high volume, low impact crimes, your typical ransomware case or whatever, where you have thousands of victims all across the world, and the individual damage may be below 500 euros in each case, but still you probably want to be able to investigate that properly and quickly. So I think there's benefits and downsides to the different ways of scoping this. But of course, the idea is not to create an instrument to prosecute bicycle theft. I mean, let's be clear about that. The measures have to be proportionate, and that's not new to the legal systems of the member states, because that's already in place for every single production order in the member states right now, because it's a principle of fundamental rights and due process.
Anyone else on this? Vanessa?
I think we should perhaps rather make a distinction between what types of data are service providers required to produce. When it comes to subscriber data, I think I don't see why there should be a threshold. And perhaps I would rather look at the level of protection of fundamental rights. The more intrusive the production order is, because you require a higher disclosure of personal information, the higher those safeguards should be. And so you would need a prior judicial warrant, for instance, when it comes to content. But I wouldn't work, I wouldn't work with a list of offenses, because that may create confusion, because what is serious and what is not serious, and it's not always clear. And as has been mentioned before, I mean, police and judicial authorities need this data very often, not only to prosecute people, sometimes also to be able to exclude them from the investigation. So it works both ways, even though we have the perception that it's very often à charge and not à décharge.
Thank you. So just to finish, a quick question, quick answer for each of you. If we're to get, first of all, do you think there will be a transatlantic agreement? And if so, how long will it be before it is established? John?
Do you have a crystal ball?
It's inevitable we'll have one. I mean, it's really, I think, as you sort of think through the different scenarios, you come to the conclusion, ultimately we're going to need it. Look, I mean, in the short term, these things are all difficult. You know, there's, you know, politics is an especially challenging aspect on both sides of the Atlantic sometimes, and right now, especially on the other. And so, but trying to, you know, but certainly we've been encouraging, and I think that, you know, we've been working on this issue with members of Congress for several years now, and I think there's the leadership in Congress understands that the way forward is by reaching international agreement that respects national sovereignty and gives people fundamental protections.
Vanessa?
I don't have a crystal ball, so I don't know. But I think we should perhaps first sort out our own situation within the EU, and then go to the Americans and say, well, this is what we have, and this can function, and then try to persuade them. I think that would be good, and it would also be good to have our foot in the door before the US-UK agreement is really into force.
Good point. Marco?
No, it's difficult to answer, but what is clear that when it comes to electronic evidence and investigations in cyberspace, then we shouldn't just regulate things among EU member states. We also just have to look further, and then we also need to find ways how to cooperate with third countries.
Catherine?
Yeah, I should take notes here, because it's really
There's
very
a whole
helpful
video
to my
available,
work
actually, so
before
you can watch all
discussion,
that
indeed.
in a couple of days.
I also, like Vanessa, I left my crystal ball somewhere, but I think it's no secret that the Commission is interested in pursuing this type of an agreement, and we've shared that interest with the US. I mean, I think at the moment there's still the enabling legislation is not in place, so even the US-UK agreement cannot move ahead because Congress has not put in place the legal foundation for the Department of Justice to be able to enter into this agreement. So I think that's going to be the next step, and once that is taken, we can see where we take it from there. But as Vanessa was saying, maybe having a unified position across the EU at that point might be a helpful negotiating position.
Excellent. We have cocktails, we have food upstairs for you. Let us first thank our panel. Catherine Bauer-Bulls from the European Commission, Marco Canopo from the Stunning Ministry of Justice and the Consul, Dr. Vanessa Franson from the University of Liège, and John Frank from Microsoft. Thank you all for participating tonight, and please join us upstairs for cocktails now. Thank you.